All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here. Raise your hand so I can make sure I have you down as being present. Kaylin Cheatham. Vicorian Fulbright. Jeremy Hester. Lori Klassen. I believe Ms. Klassen is completing paperwork for court-appointed attorneys. Andrea Pullings. Andrea Cherie Pullings. Jeremy Shelton. Jeremy Tremaine Shelton. Alejandra Mota. Jesse Epperson. For the record, Monica Roberts, CR 22, 24, and 25. Waiver of arraignment granted, pretrial set October 11th. I believe that I don't know if Mr. Green is here yet, but I believe that I've gone order that she's reporting pretrial release. Sign addition to the dates of granted. It's on file. Ashley Smith, I believe. Ms. Smith, you're here. Okay. Hunter Tapper. Braylee Littlejohn. Tyler McInnes is in custody in the Gregg County Jail. We'll recall that case. Mr. Sanders will not be appearing today. I believe he has been diagnosed with COVID. Charles Bennett. Savannah Cooksey. Ryan Dancer. Jaden Fridley. Kenneth Brunterhouse. Walter Fuentes.
Judge, Mr. Fuentes has been deported. We'd ask that you recall that later and issue 9 sign.
Ralph Henselka. Desiree Harris. Garrett Joslin.
Just spoke to him this year.
Noe Lehman. Stephen Myatt. Dylan Ostreich. Tiffany Cooey. Amber Crisp. Jamie Johnson. Gregory Bieber. Leland Cashin. Sir. Omar Galan. Billy Jennings. Chester Perry. Joseph Rushing, waiver of arraignment filed, approved, pretrial set September 20th. Danny Smith. Dakota White. Seth Atkins. Christina Beaver. Jessica Kraft. Terry DeWitt. Santana Martinez. Zachary Wooten. Is there anyone who's in the courtroom and I've not called your name?
Chris.
Good.
Present.
She is present. Yes,
I
I'm
don't
Mark.
know about including.
Yes, they were both in the courtroom. Anyone else who's present in the courtroom and I've not called your name, do you believe that you're on the docket? I haven't seen on the hands. All right, counsel, do we have anyone that's ready? I'm ready to go. All right, Mr. White. Who would you like to call first, Mr. White?
Let's call Ms. Kraft.
Jessica Kraft, CR 1847.
Your Honor, I've talked with Mr. Woodwhack on this. We're gonna ask the court to move it over to the evidentiary docket. I think that there's a chance we'll work it out. But if we don't, we'll need it here.
Okay, court will set Ms. Kraft for contested hearing on the motion on August 25th. That will be at 9 a.m.
Judge, I'm sorry, what day was that?
August 25th. Who'd you like next?
Mr. DeWitt.
Terry DeWitt, CR 22-129. Go ahead, Mr. White. We're set for pretrial.
Yes, sir. We don't have any contested motions. We're gonna ask the court to move this over to docket call.
I have September 20th and 22nd for docket call.
Let's do September 20th, Your Honor.
20th. All right, court sets Mr. DeWitt for docket call on September 20th. Mr. White, Mr. DeWitt, if he hasn't already, needs to sign his conditions of pretrial release with the pretrial release officer. We'll order him to do that today before he leaves the courtroom. Who'd you like next, Mr. White?
Your Honor, Ms. Martinez.
Santana Martinez. Ms. Martinez is set for docket call.
Yes, sir. I've talked with Mr. Woodwhack on this. I believe the state will join me. We're still discussing a resolution on this. We'd ask for one more docket call.
States on post, Your Honor.
All right, court sets Ms. Martinez for docket call on September 20th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Are you ready on Mr. Wooten?
Yes, sir.
Zachary Wooten? This is cause number CR 2255 and 56. And Mr. Wooten is set for docket call.
Yes, sir. I've talked with Mr. Woodwhack again on this one as well. We're still trying to work through it. I think we both agree that another docket call would be beneficial, so maybe we can get it resolved.
Is there anything that's lacking on discovery, or y'all just in negotiations?
We're still in negotiations, Your Honor. And partly we discussed a possible resolution. I need to get Mr. Wooten in so we can sit down and go over everything on that.
Unopposed here.
All right, state will set Mr. Wooten for docket call September 20th, 9 a.m. You ready on Mr. Atkins or Ms. Beaver?
I believe the state's going to be.
Madam Clerk, Joe. This is a 11-year-old.
Christina Beaver, CR 1110. All right, the state has tendered a motion to dismiss in this cause. The court will grant the motion to dismiss. Ms. Beaver, I do show that you were arrested in Collin County. And so the Van Zandt County Sheriff's Office needs to procure your fingerprints to report to the state for that arrest. And then the dismissal will be reported after that by the state. So I'm going to hand to you this TRN processing order. I want you to take this to the Van Zandt County Justice Center out here on 64. Just go in there, tell them you need to get fingerprinted, show them this. They're just going to take you back, take your digital fingerprints. Not going to make a change out. You may have to wait a little bit, but as soon as staff's available, we'll just take your fingerprints electronically, and then you'll be free to go. Okay. You want to sit down. I signed it the other, I think I signed it the other day. So you ready on Mr. Atkins?
I am, Your Honor.
Seth Atkins, CR 22-1, CR 22-236.
Your Honor, to be clear on the 236 case, I am not the attorney of record on that case. That's a new indictment.
Give me a second. Find out why that's on. While I'm pulling the system up, Mr. White, do you know what Mr. Atkins' intentions are, whether he intends to represent himself, request court-appointed attorney, or hire you? No, it's okay. I'm asking Mr. White. I want to know if he.
Your Honor, I filed a motion to withdraw on the, youngest case. And so I don't know what his intentions are.
Mr. Atkins, what are your intentions?
I have an attorney out of Dallas named Dan Estrada. He's my attorney. If he'll be getting back to me by Friday to let me know how much it costs. I'll be paying him from this now.
So you don't have an attorney? out
No,
of Dallas.
not as of right now. No, sir.
So Mr. White is your attorney. He's asking to withdraw from your case. Do you agree to him withdrawing from your case?
Yes, sir.
You do. Mr. White, so when you subbed in for Mr. Ashmore on the assault of a peace officer or judge case, is that correct?
That's correct.
I think the confusion is that the motion to substitute didn't have a cause number. So they just put it in all of the causes that they had for him that Mr.
Possible, Your Honor, but he hadn't been arrested on the new indictment yet. I think that just got. I got entered on that by mistake since I was representing. Over the case.
So Mr. Atkins, why do you not have your other attorney here today?
Because I got the same mix up. I thought he was representing me for that until I got the letter in the mail that he was withdrawing from the case.
Why is he withdrawing?
I guess I really don't know. I think it's because we have kind of history, or he has history with my grandmother, and the case is kind of against her, so it'd be like a conflict of interest.
Mr. White?
Your Honor, there's a couple of things. First off, my employment agreement with Mr. Atkins, that has not been met. Still, secondly, there is an issue, at least with the aggravated or the injury, newer indictment, where Mr. Atkins' grandmother is a witness in that case. Without kind of going into the facts of it, it could cause a little issue there as well.
So Mr. Atkins, how long is it going to take you to retain a new attorney?
He said by Friday he should call me back and give me his price, and I'm hiring him either way.
So you have the money available to hire the attorney that you're choosing, and you said it too? Who's your attorney that you're wanting to hire?
Dan Estrada out of Dallas.
All right, court will grant Mr. Weiss motion to withdraw on cause number CR 22-1. Court will reset that for docket call on August 23rd. Court will reset the arraignment in CR 22-236. Also for arraignment on August 23rd and status on hiring Mr. Estrada. So Mr. Atkins, I'm resetting you for 2 weeks and I expect Mr. Estrada to be back with you the next time you appear. So you understand? That all you have, Mr. White? That's all. Do we have any other counsel that's ready? All right, Mr. Elliott. Jesse Epperson, CR 22-96 and 97. Mr. Epperson is set for docket call today.
Judge, we're set for pretrial and we've agreed to reset pretrial, if it's okay with the court, till September the 22nd. I just received additional discovery within the past 7 days.
Just trying to check the system to see how I got to docket call. Give me just a moment. State. You want to respond, Mr. Elliott? State provided additional discovery within the last week.
Yes, Judge, I believe there were some additional videos that were on a USB that were just copied and turned over to Mr. Elliott. So state would be unopposed resetting at the court's preference for as far as setting goes.
All right, court will set Mr. Epperson for pretrial on, did you say the 20th?
I had 22nd.
Second.
I have another case set on that day, if that's okay, Judge.
All right, court sets Mr. Epperson in for pretrial September 22nd at 9 a.m. Once you sign, you get the yellow copy, you're free to go.
Thank you, Your Honor. May we be excused?
Yes, sir. Mr. Tyra, you stood up.
Judge, we're ready on Miss Johnson's case.
Jamie Johnson. CR 21-295.
Yes, Judge.
All right, I believe this is a status on the Quest drug test. Do we have any announcements?
Are you ready to?
Yes.
Sorry, you just trailed off.
Well, she
State-
was talking to me, so I had to listen to what she had to say. Go ahead.
I know who runs it. That's fine, Judge. State is withdrawing their motion to hold bond insufficient. The Quest laboratory is apparently unable to verify that the THC found in Ms. Johnson's system was in fact Delta 9, which we believe would be the illegal substance. So we would ask for her bond to remain as is at this time.
Anything further, Mr. Tyra?
Obviously, Judge, we have no objection to that. I did want to request some clarification. Previously in, an earlier, hearing, the court allowed, Ms. Johnson to have contact with her youngest son, Braden, through Child Protective Services. Since that time, he has aged out. And I just want to make sure that there's not any issues with her having contact with her son since he's aged out of the CPS case. It's my understanding, and he may even be present at the courthouse today. He wants to have contact with his mother, and we would like to make sure there's not any restrictions on that for Ms. Johnson.
And was the restriction and prohibition based on him being a minor at the time?
No, the restriction was based on him being a family member of the victim in this case. As the court may or may not be aware, the victim in this case was the husband of Miss Johnson at the time. The co-defendant in this case is her other son. So we've got obviously a close family unit, and she would like to have contact with her son. So.
Judge, I'm a little in the dark on this. This is Ms. Curry's case and Ms. Heisel's case. I believe our request would be that supervised by the grandmother, who I believe has custody of the child at this point. It would make the state comfortable.
Your Honor,
He's saying he's not a child anymore.
he's not a child, and he's no longer living with that grandmother. He's living with other family members. And he's 18. He's graduated from high school. He's an adult.
So have you had conversations with Ms. Curry or Ms. Heisel about amending the conditions of pretrial release to this degree?
I have not, Your Honor.
So let's do this then. We'll reset it, speak with Ms. Curry and Ms. Heisel. If they're in agreement, then you'll let me know. We can amend the orders. If they're not in agreement, you can file a motion for them to modify or amend the conditions of pretrial release, give the state notice, and we'll have a hearing.
That would be my request, Judge.
Okay.
All right, so the court takes notice that the state has withdrawn their motion to find Ms. Johnson's bail insufficient for the drug testing violation of the THC with the cannabis oil. So the court will reset this. I believe we were set for pretrial prior to the drug test issues. Where are we at on pretrial as far as discovery? Do you still need more time for any pretrial motions?
Yes, if we could just set it for the pretrial for the next setting, that I think we should make sure we have all of those issues addressed by that time if we do need a hearing on it.
Yeah, she's been on pretrial since November of last year. So I'll set it for one more pretrial, but we're over 6-7 months determining whether or not there's any legal issues for contested motion. So this will be the final pretrial.
Okay.
We'll set this. Are you available on the 20th or the 22nd September?
Yes, Judge, I can be, is it gonna be in the afternoon or in the morning?
Depends on if your client's in jail or on bail. Bail's at 9 a.m., jail's at 1:30. If she gets arrested between now and then, it'll be 1:30. If she doesn't, it'll be at 9.
The 22nd should be fine.
All right, court sets this for September 22nd at 9 a.m. All right, Ms. Johnson, once you sign and get the yellow copy, I want you to check in with pretrial release, and then you'll be free to go. Thompson, who are you ready on?
Tiffany Cooey, Your Honor.
Tiffany Cooey, CR 22-208. All right, Ms. Cooey is set for arraignment today. Are you ready, Ms. Thompson?
We are ready, Your Honor.
Go ahead.
We have received a copy of the indictment. Her name was spelled correctly. She doesn't understand the charge. Waive the reading of any form of indictment, Your Honor, your plea at this time, not guilty for purposes of today's hearing.
All right, court will enter Ms. Cooey's plea of not guilty into the record, finds that she has waived the formal requirements of arraignment. The court will set Ms. Cooey for a pretrial hearing, be available on September 20th and 22nd.
Your Honor, also she has an enhancement paragraph that we're pleading not true to.
Court will enter Ms. Cooey's plea of not true to the enhancement paragraph into the record.
And when was the reset, Your Honor?
September 20th or 22nd.
9 o'clock?
Yes, ma'am. Which one do you want, Ms. Thompson?
Sir,
Which one do you want?
that's fine.
Which
No.
one?
9 o'clock's fine.
Which one though? September 20th or 22nd?
September 22nd.
22nd. All right, court sets Ms. Cooey for pretrial September 22nd at 9 a.m. And Ms. Thompson, Ms. Cooey needs to sign her conditions of pretrial release for the court. So she needs to report to pretrial release.
Go there and tell. She says she just filled it out, signed it.
I want you to come check in with them, make sure if you have, then they'll just send you on your way. If they haven't, then we'll get it. You ready on Amber Crisp?
I am ready, Your Honor.
Amber Crisp. CR 22-209-210-211. Ms. Crisp was set for arraignment today.
Yes, Your Honor, she is. We have received copies of the indictment. Her name is spelled correctly on all three, 209, 210, and 211. She understands what the charges are, and for purpose of today's hearing, we plead not guilty, waive the reading of any formal indictment.
All right, the court will find that Ms. Crisp has waived the formal requirements of arraignment in each cause. Will enter her plea of not guilty into the record. We'll set this matter for pretrial hearing on September 22nd at 9 a.m.
Yes, sir.
And Ms. Crisp, on an unrelated but related matter, I show that there's a misdemeanor case that you were convicted on in which you owe money to the county, a little over $2,000. I have a note here that you've never paid on that. So once you sign and get this yellow copy, I'm going to order you to go down to the end of the hall and meet with the court compliance officer. And you need to talk to her about making payments on that, making arrangements to discharge it. Otherwise, the warrant's going to issue for your arrest.
Your Honor, she was supposed to be in misdemeanor court yesterday morning, and she got confused as both these dates were next to each other. And Judge Wetter said that it would be okay for her to appear tomorrow afternoon in front of him.
No, this is unrelated. This is not a new misdemeanor case. This is an old misdemeanor case, I believe, that she owes potential KPS profile.
You understand that? Yes. Your Honor, that's all I have. Maybe excuse.
Yes, thank you, Ms. Thompson. Page one. All right, this is cause number 2021-494. CR 21-341, State versus Ashley Lene Smith. I didn't know that Ms. Smith was going to be appearing Zoom today.
Well, Judge,
I'm glad she's not, but
she's not. She sent me an email this morning and said she was gonna go ahead and come back to Texas and so she could appear in person.
excellent. All right, we're set for docket call, I believe.
We are, Judge, and if the court will recall, me and Mr. Wood were working through an issue with some discovery related to a blood draw video. That issue's been resolved. We would ask the court to set another docket call so that he and I can discuss resolution of the case.
All right, court will set Ms. Smith for docket call September 20th or 22nd.
20th would be fine, Judge.
September 20th at 9 a.m. Smith, once you sign and get the yellow copy, you're free to go, and I appreciate you coming in person. Mr. Green, on Ms. Roberts, did you see the court's notation on the waiver about having her report to pretrial release?
Yes, sir. And I talked to Ms. Roberts. I told her yesterday afternoon, advised her that so she is aware.
All right, thank you. I appreciate it. If any other counsel is ready. Good morning. Remind me your name, sir.
Jonathan Apgar.
Akbar.
Yes, sir. I'm here on Alejandra Mota.
Yes, CR 22-113. And Mr. Mota, where is Mr.?
She's right here, Your Honor.
Oh, Ms. Mota. All right, Ms. Mota is set for pretrial hearing.
Yes, Your Honor.
Any contested pretrial hearings that you, or motions that you need hearings on?
No, Your Honor.
All right, so typically what I do, Mr. Akbar, is I would then set it for a docket call hearing to allow you and the state to finalize any negotiations. If there's going to be a plea in the case, if there's not, then on that docket call date, you can let me know there'll be a plea or there'll be a bench trial or request for a jury trial.
Yes, sir.
All right, are you available on September 20th or 22nd?
September 20th, Your Honor.
20th. All right, court sets Ms. Mota then for docket call on September 20th at 9 a.m.
Yes, Your Honor.
Yes, Your Honor.
Okay. And Mr. Akbar, while she's signing, I show that Ms. Mota failed to report to pretrial release in July. Do you know anything?
Your Honor, I don't have any information on that. When's the last time you reported a free trial?
Oh, I didn't know I had to report him. I had just had my court date got reset for today. So I didn't have to report.
So this is what we'll do. I'm gonna set her for September 20th, and I want Ms. Mota to come over here and report to pretrial release.
Yes, Your Honor.
Oh, I did.
Okay, you're gonna talk to them right now, and they'll make sure you understand what you need to do. Okay. Thank you, Your Honor. Anything else, sir?
Well, I do want to tell you, out of transparency, anytime that I have a defendant fail to report on pretrial, whether they claim it's a mistake or they forgot whatever, I always UA today. So I'm going to UA Ms. Mota. If she's in violation, she'll stay with me and go into custody today.
Okay,
If not, then she'll be released.
understood, Your Honor.
Okay. Just out of transparency.
But I wasn't taking.
Oh, sorry about that. Mr. White, are you ready?
All but one, Your Honor. I don't have plea papers done on one case, Omar Gilvan. but everybody else is ready to make the house withdrawal.
Okay, so Mr. Galan will be a plea.
He'll be.
We'll just start at the top then. Gregory Beaver, CR 2287.
Yes, Your Honor, this is case where actually dealing with Ms. Heisel on it, but the major problem is one of the two DVDs, not two DWIs, one of the two DVDs, one of them doesn't work. And so I'm going to need a little bit of time to be able to look at that one. I do expect this to be resolved with plea.
All right, court will reset for additional docket call September 20th or 22nd, Mr. White.
I'm already going to be here on the 20th.
20th. All right, we'll reset Mr. Beaver for that date. Once he signs and gets the other copies, free to go. Leland Cashin, CR 2149.
Your Honor, we're going to be asking for one more docket call on this. This is also Ms. Heisel's case. The only reason we are actually needing it is to confirm the plea bargain. It's going to be reduced down to a misdemeanor, but we don't know whether it's going to be a probate sentence or a time served sentence at this point. So,
You know, Mr. Woodwhite, can you confirm? Is it in your system?
I'm unaware of, I'm aware it's going to be reduced to misdemeanor as the actual terms of that plea bargain.
So there's no notes in the system or anything like that?
I expect that we'll be resolving it at the next docket call.
The notes are either time served with a higher fine or probation. So it's one of those two, I think, the actual terms, maybe once at this point. I think that.
All right, court will set a final docket call for Mr. Cashin on September 20th. Billy Jennings, CR 2227.
Your Honor, we're expecting this to be done through an agreement on a PTI. We just don't have the terms of what we're going to do yet, but I think that we may even have the paperwork done before the next court setting.
Judge, I need to discuss with probation, what our probation department's policies on certain PTI conditions are. I was hoping to do that. We would resolve it.
All right, court will set a final docket call for Mr. Jennings on September 20th. Chester Perry.
Your Honor, my record shows this pre-trial. I don't believe that there's going to be any contested matters. The one main issue that we were trying to resolve from the last time has been resolved. So if we can just place this on a docket and we get a chance to see if we can't negotiate this thing out.
All right, the court sets Mr. Perry for docket call on September 20th. Mr. White, I show that Mr. Perry's delinquent on his pretrial release fees, so I need him to report to pretrial release today. Mr. Perry, I need you to make a payment if possible. Okay? Mr. Perry, just come on back and meet with pretrial release. Danny Bruce Smith. Just one moment. Mr. Smith, next time just go on around. That's not for you to step over. It's there for a reason. It's telling you, don't walk through there. Not, I don't know if you worked at a movie theater or something, but okay. All right, next time go around.
Gotcha.
All right, Mr. Smith is set for pretrial.
That's correct. We don't have any contested pretrial. We've got an offer. I believe that once we get this set on September 20th, get all the details on it, I think we'll be resolving the case on that day.
All right, there being no contested pretrial motions, court will set Mr. Smith for a docket call on September 20th at 9 a.m. There's no request. If you want to check in with Mr. Waddell, you can, but there's, yeah, then you're fine. Yeah, I would let you know if you need to check in with him before you go.
Actually, just can't. Probably give it back to Carl. Okay.
Dakota White. I understand. I appreciate it.
This is a failed PTI based on a constant drug test. I'd like to be able to see the results because what I understand is a faint cannabis. And I wanted to have an opportunity to look at that, and I haven't been provided that yet.
All right, court will set Mr. White for docket call on September 20th at 9 a.m. I believe that's all you have, just waiting for the paperwork on Mr. Galan.
That's correct.
Ready to go. The Corey and Fulbright. All right, this is cause number CR 22-214. Mr. Fulbright, you've been charged by indictment with the state jail felony offense of burglary of a building. If convicted and sentenced, that does carry a range of punishment of not less than 6 months in prison and not more than 2 years in prison. Mr. Fulbright, do you intend to hire an attorney to represent you in this case?
Yes, sir.
Okay. Do you have the funds to hire an attorney?
Yes, sir.
If I reset your case, do you believe that'll give you enough time to hire an attorney?
Can you say that again?
If I reset your case, do you believe that will give you enough time to hire an attorney?
Yes, sir.
All right, court's gonna reset Mr. Fulbright to September 22nd. That will be for arraignment and to hire attorney. Mr. Fulbright, court's been informed that you have a warrant for your arrest for a different charge. So you're gonna be taken into custody at this time, okay? So I want you to cooperate with the officers here behind you. Mr. Fulbright, if you are unable to make bail and unable to hire an attorney based on this arrest, then I need you to contact my coordinator and let her know. That way, if you need a court-appointed attorney, then you just need to apply and let us know, okay?
What is the warrant for?
I believe it's for forgery.
What?
Forgery. Yes, thank you, sir. I appreciate it. Mr. Asbar,
Yes, Your Honor. My client has signed an admission of marijuana use. So I'm assuming her bond is going to be held insufficient. She's waiting to test and do a UA as well. I just wanted to know what the procedure would be. As I said, I assume the bond is held insufficient.
yes, sir. So the policy of the court is if there's a violation of pretrial release, either failure to report or substance use, then the court finds the bail to be insufficient and will double the amount of the posted bail. We'll take her into custody and then she can post that new bail.
All right.
So whatever the original was, you know what that is? I'll talk.
I don't have it off the top of my head.
I can look it up. I can look it up for you.
Thank
that
you,
way
Your Honor,
if you want.
just so I can let her family know.
Mr. Jackberg, there was a motion to suppress filed in this case. Is that correct?
Your Honor, I filed that just merely to preserve it, but we're not going to move forward on that motion.
I just saw that as I was in here. Wanted to make sure.
Yes, sir.
All right, yes, the bail is set at 7,000, so the court will maintain its customary policy and we'll double that to 15,000.
15,000, Your Honor.
Yes, sir.
Thank you. All right. Your Honor, I have nothing further, man. May I be excused?
Yes, thank you, Mr. Aguilar. Appreciate it.
Thank you, Your Honor.
Kaylin Cheatham. All right, Mr. Cheatham, this is cause number CR 22-205. Mr. Cheatham, I show that you've been indicted with the third-degree felony offense of evading arrest or detention with a vehicle. Mr. Cheatham, do you intend to hire an attorney? You do?
Yes, sir.
And do you have the financial ability to hire an attorney? And if I reset your case for a few weeks, do you believe that would give you enough time to hire an attorney and bring him back with you?
What date would it be?
I can give you 30 days. I can give you actually a little bit more. I could give you a September 20th or 22nd.
Yeah, that's cool.
Okay. All right. You prefer one of those days over the other?
The 22nd.
22nd? All right, court will reset Mr. Cheatham for arraignment on September 22nd and for him to hire an attorney. Mr. Cheatham, one more thing. I'm going to need you to sign conditions of pretrial release. Anytime anyone's indicted and brought to court, the court has conditions of pretrial release that attach to your bond in the case, which means that you're going to have to report to a pretrial release officer, remain drug-free, pay any fees towards your supervision, UA fees, things of that nature, okay? So come over here and meet with these officers. They're going to have you fill out the paperwork, have you sign, and then you'll be free to go. Okay? All right, for the record, and cause number CR 21-153-156-179, State versus Tyler McInnes. Mr. McInnes is set for arraignment today. Court has a notation that Mr. McInnes is set for a plea agreement in Gregg County on August 23rd. Not sure what the results of that's going to be, but we're going to reset this. Mr. Sanders, having COVID, I did not require him to appear via Zoom today. So we're going to reset till September 20th. Oh, Tyler Elizabeth. Well, we'll reset Miss McGinnis for September 20th.
Just for. Not everyone is
That's true, I understand. They're not so lucky. What about, is Mr. Harrison running late today? You think? Mr. Tapper? Motion or vote? Miss Littlejohn? All right, this is cause number CR 2231, State versus Braley Littlejohn. Miss Littlejohn, the state has filed a motion to dismiss. I show that you owe $40 for your bond supervision. Are you able to pay that today? All right, if you'll step back here and pay that with the officers, bring me a receipt. The court will sign the motion to dismiss.
My wallet. My wallet. Can I go grab it?
Yes, she's gonna bring it to you. So this is what I want you to do, Miss Littlejohn. Go over to the probation office across the street. So it's gonna be behind the mobile station over there, the Baines County Courthouse Annex. Go in there, make your payment, and then go over there, pay that, get your receipt, come back over. We'll finish your case. Okay. All right, Ms. Mota, if you'll come forward. All right, we're back on the record, cause number CR 22-113. Ms. Mota, based on your admission to using marijuana while on conditions of pretrial release, court finds you to be in violation of the pretrial release order. Court's going to find your bail to be insufficient at this time. The court has doubled your bail to $15,000, so you're going to be taken into custody at this time.
And
Right.
Your Honor, sorry,
Go ahead.
just wanted to convey what my client's position is. She was here, I believe, for her initial court setting before she had retained counsel. And I think there was just some misunderstanding as to how she needed to report or who she needed to contact with pretrial services. I've cleared that up and I've explained it at this point, but she just wanted to convey to the court that she wasn't aware that she needed to report to pretrial services to this point. She thought she only needed to show up for every court setting. I have explained to her that standard conditions of bond for a case like this is obviously no consumption of any illegal substances, and that how the bond conditions work, and if you violate it, it's totally separate from her criminal case. So I've explained that to her, but I just wanted to again convey to the court that there was a misunderstanding on my client's part.
Okay, I appreciate that. And I'm not holding the failure to report against her.
Okay,
So her bond's being found in violation due to the consumption of the marijuana.
understood, Your Honor.
I don't, it's just, it was, yeah. About the consumption,
I'm gonna advise you not to say anything.
okay.
And so, Miss Mota, your bail in this case is being doubled to $15,000. That's pretty nominal for a third-degree felony. I usually set my initial bail at $25,000. Usually my initial, and if you violate that, it goes to 50,000. So you were fortunate in that your original bail was only $7,000. And I'm going to apply the same policy to you. I'm just going to double what it was. So it's still a pretty low amount. So
And it's because of my mission, but
Yes.
like, I'm not sure whether what the drug test, like,
I'm gonna again advise you not to say anything at this, okay?
all right, so step back there with Deputy McLeod. She's going to take you into custody. You're going to go over to the jail and then you can post your new bail. We said September 20th for docket.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you. Mr. Tapper, if you'll come forward. All right, Mr. Tapper, the state has filed a motion to adjudicate and revoke your community supervision. Do you intend to hire an attorney to represent you in this matter?
Court appointment.
Have you filled out the paperwork for court appointment? Then you need to go to the end of the hallway on the left and see Miss Taberham and fill out the paperwork. Yes, sir. After you do that, then report back here. CR 22-213 Walter Fuentes. So what's the state's position on the deportation of Mr. Fuentes?
Judge, we received notification that Mr. Fuentes has been deported. We would ask for calls 3 times. I said, initial warrant. He's returned to this country. Yes.
Still out things.
Mr. Schmidt, are you ready?
Yeah, Judge, I've got the clerk, swearing, paperwork, all these weeks. We'll be ready to go to the on all the other clear announcements.
He did not. I don't know about such a thing. I don't know where I am.
I need to sit there until she drives out. Cause number CR 2263, State of Texas versus Ryan Chance Dancer. Mr. Dancer, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? Sure. All right. Put your hand down. Make sure you speak up loudly and clearly so I can hear you, so my court reporter can take down what you have to say, okay? Sure. All right. Your name is Ryan Chance Dancer. Is that correct? Sir, it is. And Mr. Dancer, are you a United States citizen? Yes, sir. And do you read, write, and speak English? Yes, sir, I do. Have you ever been diagnosed with any type of mental condition? No, sir. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you? Yes, sir, I am. Feel like you've had enough time to discuss your case with him and have all your legal questions answered? Yes, sir. Is there anything about this paperwork, Mr. Dancer, that you've read and signed that you do not understand? No. And Mr. Schmidt, do you believe Mr. Dancer to be competent today?
I do, Judge.
Can you explain to him his legal rights as they pertain to this case, including his plea bargain?
Yes, sir.
Do you believe he understands all of those?
I do.
All right, Mr. Dancer was originally charged with a first-degree felony offense of aggravated sexual assault of a child. However, I see that the plea agreement is that he would plead guilty to a lesser included offense of indecency with a child by exposure. That his punishment would be assessed today at 10 years confinement in prison, with that sentence being suspended on the recommendation of the state and probated to 5 years with a $1,500 fine plus reimbursement fees and court costs. And the state would be asking the court to dismiss DA 2021-1463, which is injury to a child under section 1245. Mr. Schmidt, is that your understanding of the plea agreement?
That is our understanding, Judge.
And Mr. Dancer, is that your understanding of the plea agreement? And that's what you're asking the court to approve today?
Sure.
All right, Mr. Dancer, a third-degree felony offense does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also includes an optional fine not to exceed $10,000. That means any sentence handed down by a court or jury on a conviction and sentence must fit within that legal range. And I see here that this proposed plea bargain would fit within that range of punishment. So you understanding the range of punishment, you understanding the plea agreement, you still wish to go forward? All right, Mr. Dancer, how do you how do you plead to the charge of indecency with a child by exposure? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? No, sir. Court will accept the defendant's guilty plea at this time. Mr. Schmidt, any objection to state's evidence, state's exhibit 1?
No, Judge.
All right, state's exhibit 1 is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. Notification received no response for our statement.
All right.
That would correspond.
Thank you, Mr. Woodwhite. Mr. Schmidt, anything further from the defense?
Yes, Judge. Based on my recollection of the law, the defendant is entitled to a copy or required to be given a copy of Chapter 62. He has not received a copy of Chapter 62 at this point. I believe that Mr. Woodwhite is producing
The normal form that provided to them, I just don't have it for now.
That's all I have, but just want to inform the court of that.
All right, the court has reviewed the evidence in this case. The court will approve the plea agreement reached between the state and the defendant. Court finds that there is sufficient evidence to convict Mr. Dancer. The court assesses sentence pursuant to the plea agreement, convicts Mr. Ryan Chance Dancer of the third-degree felony offense of indecency with a child. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence, place Mr. Dancer on 5 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $625 reimbursement fees. Court will dismiss under section 1245 DA 2021-1463, an injury to a child. The court will find that Mr. Dancer has been convicted of an offense under Chapter 62 of the Texas Code of Criminal Procedure that does require sex offender registration. Court will find that Mr. Dancer has not received a copy of Chapter 62. Court will order the state to provide a copy to Mr. Dancer. Can you do that today?
Judge, hopefully before meetings, asking my office to send it to us.
All right, court will order the state to provide a copy of Chapter 62 to Mr. Dancer prior to the conclusion of his processing today with the Van Zandt County Community Supervision and Corrections Department. court will find that Mr. Dancer is required to register under the law for the statutory time period of 10 years. All right, Mr. Dancer, you've read over your conditions of community supervision. You know what's required of you. You've discussed these with your attorney, Mr. Schmidt. You understand that if you violate a single term of these conditions, the state can file a motion to bring you back before the court and ask the court to impose sentence upon you if they can prove to the court that you violate your community supervision. You understand that? Yes, I do. And you understand what the sentence would be if you do violate? What would that sentence be? It'd actually be 10 years in prison because the court has imposed sentence today at 10. Okay, so the sentence has been imposed at 10, and that sentence has been suspended and you're on probation. So if you violate, you have a 10-year sentence. Okay. All right, Mr. Dancer, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with Deputy McLeish, and then you'll report to the probation officers over here. Jaden Fridley. CR 19-231. All right, Ms. Fridley, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, let me lower your hand. Speak up loudly and clearly for me, please. Your name is Jaden Danielle Friedley, is that correct?
Yes,
And Ms. Friedley, are you a United States citizen?
I am.
You read, write, speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
Today, in this case, you were represented by your attorney, Mr. Schmidt. Are you pleased with his representation of you?
Absolutely.
Feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Ms. Freely to be competent today?
I do, Judge.
You've explained to her her legal rights.
I have.
You believe that she understands those?
Yes.
See here that Ms. Freely was originally indicted with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. However, the plea agreement appears that she would plead guilty to that offense with the prosecution proceeding under section 1244A of the Texas Penal Code, wherein she would be convicted as a felon, but she would be punished as a misdemeanor with 5 days confinement in the Van Zandt County Jail, with her receiving credit for time served, in addition to a $1,500 fine plus court costs, reimbursement fees, and restitution. And the state would be dismissing a possession of marijuana case. Is that your understanding, Mr. Schmidt?
It is, Judge.
Ms. Freely, is that what you want the court to approve?
Yes.
All right, Ms. Freely, then how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty?
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
The court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No objection.
State's evidence is admitted. Court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing further.
All right, court's reviewed the evidence. I do find sufficient evidence to convict Ms. Freely. The court will follow the plea agreement in this case. Court hereby convicts Jaden Danielle Freely of possession of a controlled substance, penalty group 1 less than 1 gram. Court imposes sentence under section 1244A of the Texas Penal Code at 5 days confinement in the Van Zandt County Jail. Court will issue her credit for time served for those 5 days, order her to pay a $1,500 fine, plus reimbursement fees of $535, restitution of $180, and court costs of $290. Court dismisses M1931, possession of marijuana less than 2 ounces under section 1245 of the Texas Penal Code. Mr. Schmidt, is your client paying any of her fees today?
Judge, she's prepared to pay 300 today towards that balance, and we'll need to set up a payment plan for the rest.
All right, thank you, Mr. Schmidt. All right, Ms. Freely, you're hereby remanded to the custody of the Community Supervision and Corrections Department so they can carry out the terms. Actually, you're gonna be handed over to the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. And then you can make your payment, and then you'll need to set up your payment plan at the end of the hall with Mr. Pratt. Okay. You'll come forward and see Officer Burns here. Desiree Harris.
Judge, if I could interrupt the court for just a second. On CR 22-00063, Brian Chance answered. State has provided Mr. Dance with checklists punishments from the case previously. I just want to make sure the record clear. State has provided him with this punishment.
Thank you, Mr. Woodward. Ms. Harris, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may lower your hand. Your name is Desiree Sunshine Harris, is that correct?
Sir.
And Ms. Harris, are you a United States citizen?
Yes.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
Yes. Bipolar disorder.
Are you currently undergoing treatment or on medication for that? Okay, and let me finish so my court reporter can write down what I'm saying, and then she's gonna write down what you're saying, okay? All right, and in this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his representation of you?
Yes, Your Honor.
And you believe you've had enough time to talk with him about your case and have all your questions answered?
Definitely, yes.
Is there anything about the paperwork that you've read and signed today that you don't understand? Mr. Schmidt, do you believe Ms. Harris to be competent today?
I do.
You believe that she understands her legal rights and circumstances of her plea today?
Yes, sir.
And correct me if I'm wrong, Mr. Schmidt, Ms. Harris was originally charged with a third-degree felony offense of tampering or fabricating physical evidence, but the plea before the court today is on a different charge, CR 22-259, wherein the state is proceeding on a complaint and information on a Class B misdemeanor.
That is correct, with the intent to dismiss the indicted charge of tampering.
There should be a tampering charge.
All right, and Mr. Schmidt, I see that the complaint and information was filed yesterday, August 8th. Bennett's waiving the 10 days.
We are, Judge.
All right. All right, and see here that the plea agreement is that Ms. Harris would would plead guilty to the charge of possession of marijuana less than 2 ounces as alleged in that complaint and information. And the recommendation from the state is 1 day confinement in the Van Zandt County Jail with her receiving credit for time served, a $500 fine, $515 reimbursement fees, $270 court costs, and dismissing the felony charge. Is that correct?
That's our understanding of the agreement, sir.
Is the reimbursement fee correct? Would that be the indigent charge on a F3?
Judge, I believe that it was just standard contract.
Oh, this was a pre-contract.
That's correct.
Okay, all right. I thought that it was. Okay. All right. All right, Ms. Harris, then how do you plead to the Class B misdemeanor offense of possession of marijuana less than 2 ounces?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
Okay.
State's evidence is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
Nothing further.
All right, court has reviewed the evidence. Court finds that there is sufficient evidence to convict Ms. Harris of this offense. The court will follow the plea agreement, the recommendation of the state. Court hereby convicts Desiree Sunshine Harris of possession of marijuana less than 2 ounces, Class B misdemeanor, assesses her punishment at 1 day confinement in the county jail, issues her credit for 1 day time served, orders her to pay a $500 fine, $270 court costs, $515 reimbursement fees. Court does dismiss under section 1245 CR 2223, tampering or fabricating physical evidence. Mr. Schmidt, is Ms. Harris making arrangements to pay any of her fees today?
Judge, she will have to meet with compliance officer and set up a payment plan to pay the balance of her fine. I do believe she's been paying throughout her pretrial release towards her court-appointed attorney's fees.
All right, Ms. Harris. Court hereby remands you to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you come forward to be fingerprinted. And after that time, I want you to report over here to the probation officer so they can tell you how much money you owe towards your fees, because you may have a credit. Okay?
Yes, sir.
Come on up, be fingerprinted. All right, Mr. Schmidt, who are you ready?
Judge, we're ready on everyone but Henselka.
Okay. Charles Bennett, CR 22-125, CR 22-238. Charles Bennett in here.
Oh, he was right in the hallway, Judge. I can grab him. He's here. You might have stepped outside for a cigarette, Judge. I'll find him if you want to move to the next one.
Savannah Cooksey. CR 22-93, docket call.
That's correct, Judge. We'd ask for additional docket call, Ms. Cooksey. I am working with Ms. Heiser on providing her with some documents. So we're not quite ready to make an announcement as far as finalizing the case.
The objection, state. All right, court will reset Ms. Cooksey for additional docket call September 20th, suitable. Mr. Schmidt.
Yes, sir.
That will be at 9 a.m. I do show that Ms. Cooksey failed to report in July that she's delinquent on her pretrial. So Ms. Cooksey, I'm gonna have you come over here and meet with pretrial. We're gonna drug test and we're gonna talk about your financials. Kenneth Brunner House. CR 22-133 docket call.
Judge, we've reached an agreement with the state. We'd ask that it be set on that September 20th docket for the plea.
All right, court will set for plea September 20th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Garrett Joslin. CR 22-149 docket call.
Judge, we're still working on Mr. Joslin's case. We'd ask the court for an additional docket call.
State.
No objection.
All right, court will set Mr. Joslin for docket call on September 20th at 9 a.m. Mr. Joslin was late to court today, so I'm gonna UA him before he goes. Noe Lehman. This is cause number CR 22-1084 arraignment.
Yes, Judge, we received a copy of the indictment, Mr. Limon, his name is spelled correctly, understands what he's charged with. We waive formal reading, enter plea of not guilty, ask and be set for pretrial on that September 20th docket.
All right, court will find that Mr. Limon has waived the formal requirements of arraignment. Will enter his plea of not guilty into the record. Sets pretrial September 20th at 9 a.m. And Mr. Limon, I've got two things I need you to do. I need you to report to pretrial release so you can sign conditions of pretrial release. These are going to be conditions that are attached to your bond in this case. You're going to have to report, maintain sobriety, no alcohol, no drugs, make payments towards your attorney fees, things of that nature. And then also, I'm going to order you to go out to the Justice Center to where you can be fingerprinted because you were arrested in Dallas County. Van Zandt County doesn't have your fingerprints from your arrest. So we're just going to ask that you go out there, show them this order that I'm going to give you. You're going to be fingerprinted, and then they're going to let you go. You won't have to change out or anything like that, okay? So come over here and meet with the officers, and they'll give you more information. Stephen Myatt. CR 22-154 pretrial.
Judge, we are set for pretrial. Still going through the discovery on Mr. Mines' case. I'm asked the court for an additional pretrial 700.
State. All right, court sets Mr. Myatt for additional pretrial on September 20th, 9 a.m. You'll see signs and gets the yellow copies free to go. Dylan Osterreich. CR 2223, set for docket call.
Judge, I've been in ongoing discussions with Ms. Curry on Mr. Ostrike's case. I fully intend that we will resolve this matter without the necessity for a plea or a trial. However, at this point, and I talked to Ms. Curry here this morning, what we're going to do is go ahead and announce ready for trial, put it on the jury docket. And then in the interim, I believe that we will satisfy Ms. Curry's requirements for dismissal. But in the event that that cannot occur, then we'll be on the jury docket, ready for trial.
Okay, and just so I can have it for the record, what is the state's offer? I understand you're wanting the dismissal, but what is the state's offer that's being rejected today to go to jury trial? Do you know, Mr. Schmidt?
Judge, we've never received a plea offer. Our negotiations with Ms. Curry didn't take on that path. It's an unusual case. I would just tell the court that from the onset, it's been our position that it was a civil matter. Ms. Curry hasn't wholeheartedly agreed with that, but nor has she disagreed. So we've been actively working on that case from the beginning. So we never requested nor received the plea offer.
Okay. So the court will note that there was no offer made by the state. Court will set Mr. Osterreich then for jury selection. All right, court will have Mr. Osterreich appear for jury selection on October 3rd. So Mr. Osterreich, you'll appear on the second floor of the courthouse. You'll be met with my staff here. They will greet you. They will give you the information that you need. You will not go to trial on October 3rd, and Mr. Schmidt won't be required to be here. But you're going to check in, and you'll continue to do that until your case does reach number 1 setting. Okay?
Sir.
And remember that you're on pretrial release, so you need to continue reporting and doing what you're supposed to be doing.
Ready, sir.
All right, I believe it's just Mr. Hansel that we're waiting on.
No, sir, we've got Mr. Bennett,
Oh, yeah. good.
and also Jeremy Hester. We're prepared to move forward on arraignment on him.
Jeremy Hester, CR 21291. Set for arraignment, evading arrest, or detention with a vehicle.
Correct, Judge. We've received a copy of the indictment. Mr. Hester's name spelled correctly. He understands what he's charged with. We waive formal reading, enter a plea of not guilty, ask for a pretrial setting on that September 20th docket.
All right, court will enter Mr. Hester's plea of not guilty into the record, set pretrial September 20th at 9 a.m. And Mr. Hester, I want you to report at the end of the hall with the court compliance officer. I have a note here that you're over $9,000 delinquent on 3 prior felony offenses.
I told her yesterday, I didn't know that I had to pay him. I thought everything was done.
So have you already worked out a payment plan with her? Okay, all right, go take care of that so we can avoid having warrants, okay? Charles Bennett, CR 22125-238. Show that Mr. Bennett is set for arraignment on cause number 238, manufacture, delivery of controlled substance, 1st-degree felony, and he's set for docket call on the theft of property.
And Judge, as far as the arraignment is concerned, we waive formal reading, name spelled correctly, enter a plea not guilty, ask that be set for a pretrial. And carried with the original or the earlier cause on September 20th, I think will be sufficient.
Any other announcements on the theft cause? Just you want to carry it over to another
I'd
document?
ask to carry it at this time, no specific announcements.
All right, court will enter Mr. Bennett's plea of not guilty to the charge of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams. Court will set that matter for pretrial on September 20th. Court will set CR 22125 for docket call also on September 20th. Mr. Bennett, I show that you're delinquent on your pretrial release fees, $120. Can you pay those today?
I pay on Thursday. I get paid Thursday.
Pay them Thursday. I want you to come over here and meet with the officers and work that out. And Mr. Schmidt, Mr. Woodwike had mentioned your client, Mr. Fuentes, being deported. The state's recommendation to the court was call his name, issue a judgment nisi, have a warrant issued so that if Mr. Fuentes re-enters into the country, then the prosecution would continue. Do you have a position on that?
Judge, I understand the state's position. I think ultimately, short of their desire to dismiss that, that would be the only other option. I am aware that he was deported. Whether he's re-entered or not I have no idea.
All right, court will have Walter Paul Fuentes' name called at the conclusion of the docket stay. We have paperwork on himself yet, or you
Judge, I'm
need
gonna
time?
fill it out and we'll be ready to rock.
What? Lori Klassen here. She said. I didn't see. Yeah, I mean, I checked. You wrote that she's not.
No, I did not.
Oh. Is Lori Kyle Klassen? We'll just call her name and see. CR 19-143. Oh, that's a probation. For that. Okay, so we won't. I had her speak here though. Okay. Is Jeremy Shelton here? Mr. Tapper? All right, back on the record, CR 2371, State versus Hunter. Tapper. Mr. Tapper, you requested a court-appointed attorney. The courts reviewed your paperwork. You make too much money. You have too much money and assets available to you to meet the requirements for indigency. So at this point, the court can reset your case and give you time to hire an attorney, or you can represent yourself. Okay. All right, court will reset you until September 20th. So that's going to be over 30 days. So that should give you enough time to go out. I expect you to come back on September 20th with an attorney. Okay. Oh, yes, you're free to go. We'll see you back on September 23rd. All right, Ms. Pullings, come on up right here. CR 21-140 State versus Andrea Cherie Pullings. This is the sanctions status hearing. Ms. Pullings, in the last court hearing, you had some deficiencies on your community supervision. Court ordered you to complete your mental health evaluation, to pay $115 to probation, $160 to the court for your fines and court costs, and to work 12 hours community service. The court told you that if you failed to complete those, for every one you failed to complete, it was going to be a day in jail. Our records reflect that you failed to complete your mental health evaluation. It's not been supplied to the probation department. That you failed to comply with your $160 to court collections. You did comply to your payment for probation, and you did work your community service, so that's a positive.
I sent her emails to everything. Like I did get evaluated, they put me on medication and everything. I sent both of them emails. I don't understand why they didn't report them.
What about the $160 to court collections?
That I can only put some money on there today. My check wasn't enough. My old job fired me because I had child endangerment on there. They said I couldn't work around older people anymore with that case.
When did you turn in your mental health evaluation?
I got viewed over the phone. I talked to a doctor over the phone. Like as soon as she prescribed me the pills, it's like 12 of them. And I sent all the paperwork to my probation officer, the first one, this in Dallas. And then she was supposed to email, but I did it myself.
When was that?
Like a week, 2-3 weeks ago.
Which one, 2 or 3? Like, when did you do
I
it?
don't remember like the exact date.
Do you have it in your phone?
But my phone is dead. Like my case manager, I just got off the phone with her too. She was supposed to call her and let her know. Like I did everything I was supposed to do. My community service, I also did that. I did more hours. I did 27.2. And I go every single day after work. I turned that into, I don't understand why she's not reporting none of my stuff.
Well, I show that you comply with your community service. You did your mental health evaluation over the phone?
Yes, and then I went in person because they wasn't giving, I ran out of medication. They wasn't giving me the medication that was new that they prescribed for my schizophrenia. And I went in person to a doctor and he gave me the medication right then and there.
Do you have a copy of your mental health evaluation?
I don't have it physically on me, but it's in my phone. My phone went dead. Like I sent her emails and everything. I don't understand what's going on.
Well, your probation officer is saying that you didn't provide a copy.
I did. If I can't get in my phone is dead. If I get it charged and charge it up, I can show you the proof.
All right, Ms. Billings, this is what I'm gonna do. I'm gonna take you at your word on the mental health evaluation. You still have to turn that in. You need to get a copy of it and you need to get it to your probation officer, print out a copy, bring it with you. I'll take your word for it on that. Okay? But you still fell short on your court collection fees. Remember, we're just trying to get you off of probation. Trying to get you off of probation. We're not just setting numbers that we want to see.
Right track is just that I didn't know that was gonna happen. Stuff happened, and I told them too. I told them that I had that charge on me. They didn't even give me my last check, so I didn't know what to do but go get another job and pay what I could.
How long did you work on the last check that you should have gotten from your previous employer?
That one only had 12 hours in there. Cause I just had started in the paper that they was gonna get paid. So he only gave me the 12 hours and I begged him for that. Cause I told him what was going on and I had to pay my probation.
How much were you making an hour?
15 an hour.
So did they tell you when you were gonna get paid for your 12 hours?
He wanted to give me the check Friday. I begged him, he asked his boss, he said, no, I had to wait prior to that. I had to do 2 weeks in a hole and get paid that Wednesday like everybody else.
You don't pay your 160 to court collections, you just fall further behind. That means the next month, you gotta pay double to get caught up.
I mean, I could pay some money today and then I get paid not this week, but next weekend. I was gonna put money in there, pay that and what I could.
How much could you pay today?
How much did I get paid today?
No, how much could you pay today? You said you can pay some today.
The only thing I got on me right now is $27. And that was for my baby, but I gotta do what I gotta do.
All right. Is it Andrea or Andrea? Andrea. All right, Andrea. So what we're gonna do, I'm gonna reset you. I'm gonna set you off in October. That way you're not coming back every month, okay? I'm gonna set you on October 25th. I want you to do the same thing you did last month. I want you to pay your 115 to probation. I want you to pay, you didn't pay the 160 to the court. You need to get caught up on that as much as you can. Okay. I need to see big effort on that. I need you to keep on doing your hours, community service hours. And I've got to have that mental health evaluation today. Okay. So I'm taking you at your word. I think you're trying. All right. And because I believe that you're trying, I'm gonna give you a little bit of grace here for not getting the money into the court. You did lose your job, and if you lost your job because you were honest, I'm not gonna hold that against you. Okay, so I'm gonna give you time to get back up on your feet, try to get caught up. But this is what I want you to do. I'm gonna order you to make all those same payments. 115 to probation. That's every month. That's not just when you come to court. That's every month. That's what it's gonna take for you to get off probation next year. If you don't, you're either going to get revoked and go to prison, or you're going to get extended, and you're going to continue down the same road for a long time until you get caught up. Understand? So you got to pay 115 to probation, 160 to the court. You got to make sure you have a minimum 12 hours community service. If you could do more than 12 hours, that's great. Do more than 12 hours. But you got to do a minimum 12. Minimum 12. Okay. And we're gonna do a status on October 23rd. Now, what I want you to do is I want you to go over to the probation department. After you sign that, you go out and collect your babies. I want you to go over to the probation department and they're gonna charge your phone for you. And you're gonna provide that mental health evaluation today so we can get that off the plate. Understand? Any questions? All right.
Your Honor, can you verify that date? Was it the 23rd or 25th?
Oh, I'm sorry, October 25th.
Thank you.
All right, Mr. White, are you ready?
Yes.
Omar Galan, CR 2220. All right, Mr. Galan, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So you got.
Yes, sir.
All right, you may lower your hand. Your name is Omar Eloy Galan, is that correct?
Sir.
Mr. Galan, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered? Is there anything about this paperwork that you've read and signed today that you do not understand? Mr. White, do you believe Mr. Galan to be competent today?
He's competent to make the decisions he's making today.
You've explained to him his legal rights as they pertain to this case, and do you believe he understands them?
I have, and I believe he understands it.
All right, Mr. Galan, it appears that you have been charged with a third-degree felony offense, failure to comply with sex offender duty to register for life. A third-degree felony in the state of Texas does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also carries an optional fine not to exceed $10,000. Do you understand that full range of punishment? I see here that the plea agreement that the state's recommending is that you plead guilty to that charge in exchange for a sentence of 3 years confinement in the Texas Department of Criminal Justice, with that sentence being suspended and you being placed on community supervision for 3 years, in addition to fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Galan, then how do you plead to failure to comply with sex offender duty to register? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we arrested.
From the defense?
Nothing, Your Honor.
Court's going to review the evidence. All right, the court's reviewed the evidence. I do find sufficient evidence to convict Mr. Gallant of this offense. Court will follow the plea agreement as recommended by the state. Court hereby convicts Omar Eloy Gallant of failure to comply with sex offender duty to register. Court hereby assesses sentence at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence, place Mr. Gallant on 3 years supervision, order him to pay a $1,500 fine, $290 court cost, $35 reimbursement fees. All right, Mr. Gallant, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with Deputy McLeish. After that, I want you to report to the probation officers. That's Lori Clausen is not here. Ms. Christine. Fix it. You missed it right here. All right, we're back on the record. Clause number CR 2293, State versus Savannah May Cooksey. The court has set Ms. Cooksey for a docket call on September 20th. Ms. Cooksey, I had a note that you failed to report as previously ordered in July that you were delinquent and that you were late to court this morning. So I asked that you be sure that your analysis test. And I have a form here that says that you've acknowledged that you smoked marijuana today. All right, Ms. Cooksey. Mr. Schmidt, you want any testimony? You want any? All right, Ms. Cooksey, you know that's a violation of your pretrial release in this case. And listen, I'm not asking you to say anything other than to acknowledge. I don't mean to cut you off, but I'm not asking you to explain yourself. I just want you to be clear that you understand that you can't smoke marijuana and then come to court without there being consequences. Okay. So Ms. Cooksey, the court's going to find that you have violated the conditions of your pretrial release. Court is going to find your bail to be insufficient. The court's going to double your bail, take you into custody at this time. All right. We'll go with that, please. I don't have anything. Mr. Johnson, come on down. All right, we are back on the record. Cause number CR 22-149, State versus Garrett Lee Joslin. The court has set Mr. Joslin for docket call on September 20th. Court has directed the Community Supervision and Corrections Department to administer a urinalysis on Mr. Joslin, who was late to court today. Mr. Joslin, I have a form here that says that you've admitted or acknowledged that on August 8th, yesterday, you smoked methamphetamine and marijuana. That's a violation of your conditions of pretrial release in this case. The court's going to find that you have violated the conditions of pretrial release. The court's going to take you into custody. The court's going to double your bail in this case. Mr. Schmidt, any questions or anything? No, you need to see that at all. Thank you. All right, we take Mr. Johnson to custody at this time. I will leave. Make your copy. Yeah, I'm honest. Yeah, I'm going up to the copy of these. Are we ready, Mr. Hanselman? Mr. Woodwhite, you have the paperwork. Yes, you go ahead, Mr. Schmidt. I was got Mr. Woodwhite bring the paperwork on Hanselman. Can you bring that to us? All right, Mr. Hanselka, you'll come forward, please. All right, this is cause number CR 21-169, CR 21-170, State versus Ralph John Hanselka. All right, Mr. Hanselka, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So if you got, all right, put your hand down. Your name is Ralph John Hanselka, is that correct? Yes. And sir, are you a United States citizen? Yes. Do you read, write, and speak English? Yes. And have you ever been diagnosed with any type of mental condition? No. In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his representation of you? Yes. like you've had enough time to talk with him about your cases and have all your legal questions answered? Yes. Anything about this paperwork that you've read and signed today that you do not understand? Mr. Schmidt, you believe Mr. Henselka to be competent today?
I do, Judge.
You've explained to him his rights. Do you believe he understands them?
Yes, sir.
All right, Mr. Henselka, I see that you have been charged with 2 crimes. 1, escape while arrested or confined, a 3rd-degree felony. 1, assault of a family or household member by impeding breath or circulation. See that the plea agreement in this case is that you would plead guilty to the escape while arrested or confined. State would be recommending that your sentence be assessed at 6 years confinement in prison, with that sentence being suspended and you being placed on community supervision for 4 years, plus a $2,000 fine, court costs, reimbursement fees of $35. The state would dismiss the assault charge and also an interference with emergency, a misdemeanor offense. Is that your understanding of what you want the court to approve, Mr. Henselka? All right, Mr. Henselka, escape while arrested or confined with a felony is a 3rd-degree felony offense. It does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also an optional fine not to exceed $10,000. You understand that range of punishment? All right, Mr. Henselka, understanding the plea agreement and the range of punishment, I'll ask you at this time, how do you plead to that offense? Are you pleading guilty to that crime because you are guilty of committing that crime? Absolutely. Has anyone threatened, forced, or pressured you to plead guilty? Yes. The court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state? What about victim compliance on the 1245 assault?
Judge, stays in compliance. We have received no response to any attempt to contact me. CR 21 once.
All right. Anything further from the defense?
No objection.
All right, court will review the evidence. And I'm assuming that the state is abandoning the enhancement paragraph in the indictment. Council, will you approach? All right, court's reviewed the evidence. Court will find that there is sufficient evidence to convict Mr. Ralph John Henselka of this offense. Court will follow the plea agreement based on the recommendation of the state of Texas. Court hereby convicts Ralph John Henselka of escape while arrested or confined for a felony, a third-degree felony offense. Assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place him on community supervision for a period of 4 years, order him to pay a $2,000 fine, $290 court cost, order him to reimburse Benson County $35. Court will dismiss pursuant to the plea agreement CR 21-170, the assault case, and DA 2021-355, the interference with emergency request. All right, Mr. Henselka, you hereby remanded to the custody of the Benson County Community Supervision Corrections Department, so they can carry out the terms and conditions of the sentence. And have you step forward to be fingerprinted. After that time, I want you to report to the probation officers. Yes, sir. I'll write this on the record.
No. Wait.
So was there any response for Walter Fuentes?
No response, Your Honor.
All right, cause number CR 22-213, State Texas versus Walter Paul Fuentes. Court called his name at 9 a.m. He was not present in the courtroom. He's not present at this time, which is approximately 10 till 12. His name was called loudly, distinctly in the courthouse with no response. Court hereby issues a judgment not signed alias capias. Court will double the bail for Mr. Fuentes. All right, that concludes the morning docket. We're going to stand in recess. Afternoon docket will begin at 1:30.